I'm Gerard Berga, and welcome to episode 21 of the Florida Family Law Attorney Podcast. And today we have somebody on who I've had the pleasure of litigating against, I've had the pleasure of working with, and somebody through the years I have learned to call a good friend. He's attorney Jerry Rumph. He's a board certified attorney out of Tallahassee. He focuses a lot of his practice on complex family law issues and appeals. And I always have found that when I discuss appeals with people, that's something that's very mystifying to them, something they don't have a lot of information on. So when Jerry was willing to come on and do the show, we really wanted to have Jerry on so he could explain the appellate process and what it means to be an appellate attorney and some of the developments going on in that body of law. And it's just an honor to have you here, Jerry. That's my little brief intro. Why don't you tell the audience a little bit about yourself?
Sure. Thanks, Gerard. Yes, Jerry Rumph. I do practice out of Tallahassee with the firms of Brooks Law and Brooks and Rumph. Board certified marital and family law since 2019. I've been practicing law since 2010. And I agree, probably my biggest accomplishment is being able to call you my friends. It's been a pleasure to work with you over the years, and I appreciate you inviting me on to the podcast.
We're honored to have you, and I feel likewise about your friendship and our professionally and personally. I'll say this: when we have weird issues that come up, when we suspect the judge maybe got it wrong or is going to get it wrong, and we want to try to preempt that, we call Jerry all the time for most of our appellate issues that we have or issues that we see are going to go that direction potentially. And so, it's always, in my opinion, a great resource to have if, you're litigating these cases at the trial court level, to have the appellate lawyer on speed dial, because you never do know. It could be in the middle of the case. It could be the night before that something has happened. And you want to make sure that, the best course of action is if you can prevent the appeal, prevent it. If you can't prevent it, then make sure you have the record, there to support the appeal, and that you've given the appellate attorney like Jerry all the ammo he needs to take it to the next level, so that he can, hopefully successfully litigate the matter there. So Jerry, like we talked about, you're a board certified marital and family law attorney. You handle trial work, you handle appeals. What drew you to focus on appeals and family law cases, honestly?
Well, I enjoy the work, honestly. I enjoy the process of writing, whether that be professionally or creatively. Been writing for, concentrating on written product for a good sum of my career. I believe written advocacy is an art form. Not many people want to do it because they find it either to be tedious or pedantic. But I'm an honest, diehard, pedantic individual, so it's enjoyable to me. And I have forays into academic writing, academic research, taken some PhD coursework written in the law and literature realm. And so I just really enjoy digging in, doing the research, doing close reading of cases, statutes, that sort of thing, and trying to come up with an argument to convince the courts that my client's side is the way to go. It's in line with the law, that it's the point of law that's appropriate for the appellate court to adopt. So I enjoy it, and I have a lot of fun with it.
For those out there who've never had the pleasure of being involved with an appeal or the pleasure of drafting an appeal, because I think almost everybody in law school gets to do one at least their first year.
Right.
There's a big difference. I think a lot of people who are new to family law or just, have a family law case, they think about lawyers and that we make these arguments in court and we're questioning witnesses and it's, not that much writing. But then when you switch into really appellate work, it's for people who don't have any experience. The appellate court gets a record. It's normally a transcript and the documents that are part of the docket that are filed with the court. And then that's called the record. And then you have an appellate attorney like Jerry here who writes the brief or the reply brief. And, it's all written argument. And while sometimes they have some oral arguments, they're not all the time. And, a lot of times the whole crux of that appeal depends on the words and the written word on the sheet and how compelling it is and the details that go into it, because it's very detail oriented when you're arguing, these little nuances of the law. And, Jerry, if you could, what is an appeal really? Like, can you kind of break down the fundamentals of it for those who've never had
Sure.
this experience?
Yeah, absolutely. So appeals are where one court reviews another court's decision, ruling, and ascertains whether either it was correct under the law or whether it had the evidence necessary to support the factual findings. And it may be, for a broader audience to understand that Florida has generally four levels of courts, two of which are trial courts and two of which are appellate courts, or county courts, circuit courts, district courts of appeal, and the Florida Supreme Court. Our cases are generally heard at the circuit court level in the trial arena. And so, Gerard, when you and I are handling a case together or against each other, a lot of times it starts out in the circuit court. And, you have offices across the panhandle and have had offices in other parts of the state. But your main office being there in Panama City Beach on Richard Jackson, you're in the 14th Judicial Circuit Court. With me being in Tallahassee, my office is in the 2nd Judicial Circuit Court. Both of those, though, are within the territory of the 1st District Court of Appeal, and there are 6 district courts of appeal in Florida. And so for us, most of the appeals that you and I work on together are handled by the 1st District Court of Appeal, the 1st DCA. And so the circuit court, the way it gets there is when the circuit court enters an order or a judgment that we need to have reviewed by the appellate court. Once we get through, motions for rehearings and motions for reconsideration, asking the circuit court to reconsider what it did. And ultimately, if we need to take it up to the appellate court, we file a notice of appeal with the circuit court. The circuit court is then put on notice that an appeal has been filed, and that is then transmitted to the appropriate district court of appeal. Again, in our geographic territory, most of the time, that's the 1st District Court of Appeal. And then the 1st District Court of Appeal, it enters or issues a lot of orders and letters acknowledging the appeal, telling you you've got to file or pay your filing fee, file a docketing statement, that sort of thing. And then depending on what kind of an appeal it is, whether it's a non-final or a final order, determines how long you have to start filing your initial brief. If you want to serve directions to the clerk to limit the record, certifications to the court reporter, that sort of thing. So it just all kind of depends on what sort of order you have, on the time frame, and what you're doing.
One of the things I think it's fascinating, and I think it's something that a lot of family law attorneys, I think, struggle with is, the appellate courts, we think they just do appeals, but they actually do a wide variety of other very, very complicated and complex tasks that are mostly in Latin, which everybody loves. Can you explain like writs of certiorari, writs of prohibition, mandamus, those things? Because to me, that's where it gets really interesting and abstract as to what the standards are and when you can file one, when you can't file one, and the relief. And I think that's kind of an interesting thing that a lot of people have no idea, that they just don't do appeals, they do other tasks as well.
Yeah, so there are other types of proceedings, you're right, that the appellate court hears, and that's first and foremost established in the Florida Constitution that gives them the authority to do that. And then those constitutional provisions are mostly enshrined in the Florida Rules of Appellate Procedure, which are found in Chapter 9 of the Florida Rules of Court Procedure. Whenever I want to reference those, I always go to the Florida Bar website. You can even type in Google Florida Rules of Court Procedure, and then I reference the ones, again, that are linked on the Florida Bar website, because the Florida Bar website generally has the most up-to-date version of those whenever they're amended by the Florida Supreme Court. And that's how our rules of procedure are created. The Florida Supreme Court creates those, including the Florida Rules of Appellate Procedure. So under Rule 9.100, there's a rule called original proceedings that discuss petitions for writ of certiorari, petitions for writ of prohibition, writs of mandamus, quo warranto, and these are called extraordinary writs. They're things that the court doesn't grant or employ very often in exercising its jurisdiction. In our cases, the ones that we'll see the most are petitions for writ of certiorari or petitions for writ of prohibition. Petitions for writs of certiorari are asking the appellate court to look at something the trial court did that may not be reviewable by an appeal. And the rules of procedure that I was talking about, the appellate rules, specifically describe what orders the appellate court can review by appeal. If you can't get into one of those categories, then you can try to file a petition for writ of certiorari, which the appellate courts can use to see if the trial court departed from the essential requirements of the law, and that departure is going to cause irreparable harm or something that you can't fix on final appeal of the order. And so the court has to have these jurisdictional requirements that's going to cause material injury, that can't be remedied on plenary appeal. And those two things are generally considered the irreparable harm necessary for certiorari relief. And if the court doesn't have those things, if the petitioner can't show that those things exist, then the appellate court is going to deny the petition for writ of certiorari. Prohibition is employed to prohibit a lower court from exercising jurisdiction it doesn't have the authority to exercise. Or most often, we will see it when somebody asks the trial judge to disqualify him or herself due to some perceived prejudice or bias or actual prejudice and bias, and the trial court denies the motion to disqualify. Then you file a petition for writ of prohibition to address that with the appellate court. And the appellate court looks at, the law to see whether the trial judge should have disqualified himself or herself. And you're going to be looking at Chapter 38 for statutes for that, and Rule 2.330 for rules of general practice and judicial administration.
Well, let me try to break it down. I'll try to give an example, and I might be wrong.
No, come on.
This might be easy for people to understand, and you can tell me if I'm right or wrong, or maybe we can come up with an example. As I know when I was learning abstract stuff like that, sometimes the example kind of resonates at home. So let's say I'm ordered to disclose some privileged information,
right,
in discovery. Maybe it's an email between my attorney and myself, and the judge orders me to disclose it, even though I've asserted the privilege. And would that be something that would, potentially trigger certiorari review since it's not a final?
That's exactly right. That would be petition for certiorari. You nailed it right on the head, Gerard. Something like that. Potentially, let's say, there's someone who is collateral to a divorce proceeding, say a family member or a friend, and one side tries to subpoena their personal financial information in the case. That person who's not a party to the proceeding, and even the parties to the proceeding, though, their rights of privacy are substantially curtailed. But someone who's not a party to the proceeding is going to have stronger rights of privacy in their financial information. And so if someone's trying to get their bank account information, credit card information, or something like that, they might hire an attorney to file a motion to quash or otherwise attack that subpoena going to their financial information. And if the trial court denies that motion to quash, then they would have the right to file a petition for writ of certiorari as well. Again, showing, look, if you let this information out of the bag, the other side's going to have it, or these people are going to have it, and they don't have a right to it. And there's no way to put that cat back in the bag, by the time we get to a final judgment and we have this issue appealed. So I need you to protect me now.
Let me ask you this. So in my hypothetical, the judge has ordered the email between the client and the attorney to be disclosed or discovered, and you want to challenge that. When you file the writ of certiorari, does that automatically stay the trial judge's order? How does that work so you don't have that irreparable harm?
No, it doesn't. So you would need to file a motion to stay pending review under Rule 9.310 of the Florida Rules of Appellate Procedure, and ask the trial court. You first file that motion with the trial court, and you ask the trial judge, I'm asking you to stay your order while we have this reviewed with the appellate court. And you've got to give the judge then the chance to do that. If the judge says, no, we're not going to do that, then you file a motion with the appellate court asking them to review the denial of that motion to stay pending review. The only automatic stay, if I'm remembering correctly, under Rule 9.100 is if you file a petition for writ of prohibition and the appellate court enters an order to the other side to show cause why the petition shouldn't be granted, then that automatically stays the proceedings below. But otherwise, there's not an automatic stay. Although in the case like what you've cited, disclosing attorney-client privilege matter, or a non-party trying to protect their privilege, or their right of privacy, their constitutional right of privacy, things protected under that, their financial information, healthcare information, things that are really protected under the law from disclosure. Generally, you'll get your motion to stay pending review granted in that situation, because it's safer to put a hold on it than it is to say, nah, go ahead and release it. But then if we're wrong, try to take it back. I mean, that's the whole reason you would be filing the petition for writ of certiorari.
Yeah, there's just unfortunately no way to put it back, like you were saying. So, people going through these cases, family law, especially, I think, want it over as fast as they can. They want to get it behind them. They want to, restart their lives and move forward, hopefully, and start rebuilding. So I know we get asked at the trial court level all the time, how long? How long does this take? What's the timeline? So, one of the things I think is interesting in, what is the timeline for an appeal? What's the timeline for writ of certiorari? Can you explain that to us? Because it's been something through the years where I've honestly just felt like we're waiting and we're waiting and we're waiting. And I don't really know what deadline they have to actually enter a ruling. 'Cause I've seen it last a long time.
Yeah. So with the appellate courts in particular, I know it can kind of feel sort of like a Wizard of Oz experience. Maybe there's these people behind a curtain that you can't see, and you don't really know what's going on. And like you said in the beginning, most of the time the appellate courts will rule on the paper, the briefs that are filed, motions that may be filed, without the benefit of what's called oral argument. And in most of the DCAs, I find that that's the case, that they rule on the briefs that are filed. And unless oral argument is going to advance the law in some substantial way, going to advance the court's understanding of it, resolve some point of law, that where the panel may be unsettled, or maybe the law is unsettled, or even a case of first impression of some sort, most of the time that's it. They're going to rule on the briefs. Now, if you have an appeal from a final order, unless it's some sort of, unless the court orders otherwise, the initial brief doesn't have to be filed until 70 days after the notice of appeal is filed. And that gives time for the clerk of court to transmit the record, to deal with getting transcripts, to deal with some ministerial stuff, that needs to happen. If there's an appeal from a non-final order, then the briefing schedule is generally much more accelerated. That initial brief is served within 20 days after filing the notice of appeal. And you don't need as much time with an appeal of a non-final order, because the clerk of court doesn't transmit a record in those cases. The appellant is responsible for submitting an appendix with the initial brief. And so the burden is on the appellant to not only draft the initial brief, but to assemble the documents, the orders, the transcripts, the motions, anything else, within the record before the court, or other matters that are allowed to be included in an appendix. You're charged with assembling that and providing it to the appellate court when you file the initial brief. So you don't need as much of that. At least I guess the thought is you don't need as much of that intervening time from the notice of appeal to filing the initial brief. Plus you're dealing with non-final orders. So they want you to file things faster so as to move it along faster, because they recognize you have the underlying case still going on if you're dealing with a non-final order. So sorry, Gerard, to extend upon that. So after you file the initial brief, there's 30 days to file the answer brief, and then 30 days to file the reply brief. And that's barring any extensions of the time to do that. And those timeframes can be found in 9.210. And that rule not only tells you the time for filing brief or serving briefs, but also other requirements regarding the briefs. So there are procedural requirements that govern the structure and format of these briefs, but the time frame can be filed in that, or the
So let me ask this. I think this is the natural follow up of what a lot of people want to know. Obviously, you file the initial brief. There's the response. There's the reply brief that the appellant, gets to reply, and all this gets turned in, and we're done on our end. Is there a timeline that they have to actually rule within? Because I've seen some come back really fast. I've seen some that we're waiting and we're waiting and we're waiting, and it's always been the mystery to me as you talk about like the Wizard of Oz. What is the time frame that they have to respond in, or is it just at their discretion?
Yeah, there are ideals set again by rules of procedure and whatnot, but the true and honest answer is it depends on the case. It's a case by case basis. It largely depends on what issue they're reviewing and how complex the issue or issues are that are raised, how big the record is. I've seen cases come back within a few months after briefing is finished, and I've seen them come back in 18 months after briefing is finished. It just really depends on issues involved, the size of the record. I mean, there can be records that are thousands of pages, and the appellate court reviews that, especially depending on the issues involved. And we'll get to this a little later, but there are things called standards of review on the issue. So it depends if the appellate court has to dive in just to the law or if they've got to go into the facts. And so, the level of review that the court's being asked to do. Now, you can file motions to expedite the appeal. I've only filed one emergency appeal in my career. Otherwise, I generally let the appellate court do the work they need to do because I want them to take the time that's necessary for them to take to sort through things and sift through things. I don't want to disrupt the process there at the appellate level. Usually I represent the appellant. I do represent appellees, certainly, but a lot of times I'm representing the appellant. Again, I want the appellate court to have the time necessary, not just to review the briefs, but to go into record and look at it and come back, with a full decision on the merits.
Let me ask this, and this is just a off topic, off script question, but just question I always wanted to ask, and maybe you have the answer to it. I've seen a lot of what they call PCAs, per curiam affirmed, where you don't really get a written opinion, and I've seen those when the brief has been out for they've been reviewing it forever for long periods of time. I've seen it happen short. Do you think that the longer they take, I know it's no hard and fast rule, but do you see any correlation between the amount of time versus them really digesting it and writing an opinion, or is it just any man's guess?
It's any man's guess. It's this man's guess. So I've had a similar experience where you could file something and it's been out for a while and you're like, surely I'm getting a written opinion on it, whether they're going to reverse or affirm or
Yeah.
whatever. I don't know what it's going to be, but surely I'm getting a written opinion on this. And no, there's a PCA. Oh, yes, it is a mystery on the PCA. And to talk about the PCA, if you don't mind me
Yeah.
speaking about a little bit. So it stands for per curiam affirmed. It means that the appellate court, after it conducted its review, that they did not find that there was anything either. And it doesn't mean that the appeal is meritless. It just means that they didn't find anything that would advance the understanding of the points of law raised or points of law that need to be addressed that was worth issuing an opinion. And there are great Florida Bar Journal articles out there. I think there's one, it's like, oh no, not a per curiam affirm or something along, I'm paraphrasing, but there are articles out there that talk about PCA opinions and what they mean, why they exist. And frankly, they exist because the court's work isn't going to advance the points of law, that are already in existence in an area, than to take up the judiciary's time to write, these opinions when it's already been written before. Something that's like, this has already been written on, we disagree that we need to write on it any further. The trial court, didn't depart. There's no reversible error. The facts are supported by competent, substantial evidence. The court applied the law correctly, so on and so forth. There's just no reason for us to elaborate on this further. So they're allowed to, and they don't. And I know that it can be frustrating for the appellant, especially because you're like, I've got this great argument. I know I do, and everything. And the other thing that people, and again, it kind of gets into those standards of review. What the trial court did often goes to the appellate court, what is called clothed in the presumption of correctness, meaning that it comes to the appellate court with the presumption that the trial court got it right. And it's up to the appellant to say, no, you didn't. And that goes into why it's important to have a full record and that sort of things. But, if you didn't convince them that the trial court didn't get it right, more often than not, there's going to be the PCA, that comes out, and that's just it. So
I'll tell you this as a practitioner, when we've had stuff go out to you or out on appeal and we get a PCA and we're the appellant, is very hard to justify the time and the expense to the client when you get that. And I always find that that's a gut punch to a lot of clients when they see that, because they do want an explanation of why, or a little more detail, because they thought they had a meritorious argument.
sure.
I always feel bad when I see those. I understand the purpose of it academically, but it can be very hard to the average person who's not a academic to understand why did they not get the decency of an explanation.
Right.
Anyway, that's not for me to pick apart, but always
I
always feel bad.
Yeah, I agree with you, Gerard. I often try to explain that to people when they're the appellant, especially when they're starting out. Now, if I represent the appellee, I tell them, we're striving for that. That's what we want. But if we're representing the appellant, I try to always explain to him that that's a possibility, to the appellant, to he or she, that's a possibility, that there could be a PCA, that we could put in this effort. It's an expensive process. It's a long process, and it could come back and there are 3 words: curiam affirmed. And that's it, and then we can file a motion asking them for a written opinion, trying to convince them, that there's something, there, there's some nugget there that warrants the written opinion. But more often than not, that's going to just be, the motion is denied. And the explanation is, again, it's not that it wasn't meritorious. It's just that, the appellate court, in reviewing everything, decided that the trial court, it wasn't worth, discussing how the trial court essentially got it right. Because when they say that last word affirmed, they're saying the trial court got it right. And there's no reason for us to explain it to you why the trial court got it right. So,
I feel like while we're here, I know again it's a little bit off script and a little bit off topic, but there's the PCA, but then there's also the mandate. Can you explain what the mandate is? Because that's the kind of the other side of the aisle when you get the mandate.
yeah, so you first get the opinion from the appellate court and explaining, or again, even if there's a PCA, but you get the opinion saying, this is our review of things and our opinion on it, and what we think it is. And then the time frame goes by to file motions for rehearings and motions for written opinion, motion for clarification, all of those motions that you can file after the opinion is issued. And that period has to lapse before the mandate is issued. Because sometimes, and I've had this, I've filed a motion for rehearing, I've filed a motion for clarification, and the appellate court has said, you know what, we're going to correct the opinion, or we're going to clarify the opinion, we're going to do something that adjusts this opinion in some way. And so it's not the final, determination of the court. It's not the final opinion of the court or ruling. And then the mandate, though, when it finally issues, is that's telling the trial court the appeal is final and you are to proceed forward, trial court, with however we've ruled here. If they've reversed what the trial court has done, then a lot of times they remand with instructions consistent with the opinion. And so they tell the trial court, we did not agree with you on these points. And so you need to go back and either fix your determination on the law, or you need to take more testimony. You need to make additional findings, whatever it is that they've disagreed with. And then that mandate instructs the trial court to go, do those things.
Tell us a little bit about, there's obviously civil cases like car wrecks, slip and falls, those things. And then there's family law, which is its own kind of animal. What are the differences in a civil appeal and a family law appeal? Are there anything stands out?
Well, the biggest difference, I mean, at first blush, no. Family law cases in Florida are civil cases. They're not criminal cases. They're not administrative cases. They're a special type of civil case. They have their own special rules of procedure under Chapter 12 of the Florida Rules of Court Procedure. And those are the rules that govern family law proceedings. But one sort of nuance about family law appeals is that they have more areas of law that are appealable, that the court can enter a non-final order during the course of the case. For example, the court might grant temporary alimony or interim attorney's fees or an interim partial distribution of marital assets. It can enter these temporary orders. It might establish a temporary parenting plan or something of those, something of that nature. And under Rule 9.130 of the Florida Rules of Appellate Procedure, it lists out all the appealable non-final orders. And these are things that you can appeal. You can file a notice of appeal. You don't have to file a petition for writ of certiorari or a petition for writ of prohibition or something like that. You can file a notice of appeal and appeal these non-final orders. Rule 9.130, and I have the rules open on my screen right now just for easy reference. But those special determinations are under that rule, and specifically they're to determine an order that determines a right to immediate monetary relief. So again, temporary child support, alimony, attorney's fees, and interim partial distribution of marital assets, anything like that, you can look at appealing as a non-final order. Rights or obligations of a party regarding child custody or time sharing under a parenting plan. Again, if the trial court says, I'm going to order you guys to do this on a temporary basis and you think it's wrong, or if the court says, I'm not going to give you any time sharing on a temporary basis and you think that that's wrong, you can appeal that. Or if the court modifies time sharing on a temporary basis, let's say the parties have been, let's say it's a former husband, a former wife, they've been divorced, they have kids, there's a parenting plan in place, a few years go by and somebody seeks to modify it in some way. And the trial court does and says, I'm going to change this. Okay. And you think the trial court was wrong for doing that, you can ask the appellate court to review it. And then the other area is that whether a marital agreement, either a marital settlement agreement, a prenuptial agreement, a postnuptial agreement, whether it's invalid in its entirety. So if the trial court says this thing, it's invalid in its entirety, that's something that you can appeal as a matter of right under Rule 9.130. You don't have to wait till you get to a final order or a final judgment to deal with that.
So I know we talked about this a little bit before. We were talking about the writs of certiorari and what happens to the order. But when we're dealing with final orders and non-final orders, and we're actually going to appeal them, what happens to the underlying order when you file your notice of appeal, and what do you have to do?
So you can seek to stay the proceedings pending the review of the non-final order. And I always argue that for purposes of judicial economy, that's the right thing to do, because the trial court, when it gets to a final hearing in a family law matter, it often has to consider how things exist at the time of the final hearing. And so what's in the best interest of the children at the time of the final hearing, not when the case was filed, 2 years prior, but right now at the final hearing. What is the party's financial situation now at the time of the final hearing? There are things that the trial court has to consider then and there before it orders, certain relief. And, for example, if a divorce is filed and then 2 years goes by and then you get to the final hearing, one of the parties may have been employed, they may not have been employed, things could happen in their financial situation that changes whether or not alimony is appropriate, or changes, what the child support should be, all those things that happen. And so I argue that if you're going to file an appeal of a non-final order, it doesn't really make sense to go to the final hearing. And here's the kicker under the rule that talks about appealing non-final orders is it says, and this is Rule 9.1F, it says, stay of proceedings in the absence of a stay during the pendency of a review of a non-final order The lower tribunal, meaning the trial court, the circuit court, may proceed with all matters, including trial or final hearing, except it cannot render a final order disposing of the cause pending such review unless the appellate court says that it can. So the trial court can go ahead if there's no stay entered, okay, while the non-final order is being appealed. The trial court can proceed to a final hearing, but it can't enter a final judgment. And so if you've got an appeal of a non-final order that's going to last months to even a year to over a year, why are you going to have a trial and then wait for the order to come out, whether that be on alimony or whatever, if you can't enter that final order? So to me, for purposes of judicial economy, for purposes of finality, it doesn't make sense. And I would argue you could run afoul of the appellate court's jurisdiction and what they're trying to do if you go too far while an appeal of a non-final order is ongoing, is pending.
One thing I always found interesting, and I'm going to let you lecture us on it and educate us on it, is Rule 9.600C. And how that impacts the family law process during an appeal.
Yeah. So Rule 9.C talks about the jurisdiction of a trial court in family law proceedings. That rule says family law matters, and then there's 1, 2, and 3 about what the court can do while an appeal is pending. And the rule seems pretty broad, especially on financial relief, that says the trial court can award maintenance, attorney's fees, alimony, child support while an appeal is happening. And it says, or other awards necessary to protect the welfare and rights of any party pending appeal. And so you look at that and you're like, man, the trial court can pretty much just continue on, regardless, especially in these financial matters while the appeal is pending. But there are cases out there. There's a case, Campbell v. Campbell. There's Travis v. Travis. They talk about how that rule is actually one of limited jurisdiction, and that if the trial court tries to exercise its jurisdiction while an appeal is pending on a matter, let's say we file an appeal on the alimony, okay, and then the court tries to enforce that alimony award while the appeal is pending, it's arguable that the trial court would be usurping the appellate court's jurisdiction to make a determination on the appeal. It's almost saying, like, I don't care that the appeal is there, we're going to do this anyway. The counter argument to that, though, is, you've got a person with the impecunious spouse. They could be destitute without financial relief. So you've got to strike this balance of, how do we protect this person while the appeal is pending? Because again, we could be talking about months, we could be talking about a year. So how do we protect them and keeping, that financial relief in place for them while this is happening? Balance that the rule is intended to strike, I think, is to respect the trial court's discretion, because the appellate court can't award alimony. Okay, the trial court has to do that. So the appellate court can only review if the trial court's determination of alimony is correct. So the trial court is in the best position and has the best discretion to determine, how do I strike this balance in, protecting this party while also recognizing the other party has appellate rights, that they are allowed to assert. So,
well, you touched on it a second ago, but not all appeals are created equal, and they have different standards of review. And I remember, us having to learn that in law school, and it's still something that I keep in the back of my file when I'm doing a case and thinking about, if this goes up on appeal, what is the standard of review? Because that really determines what your burden is, what you're up against on the appeal. Could you mind just taking a few minutes and kind of breaking out the different standards of review you see in family law and kind of giving some examples of those?
Sure. For the appellant, so there are multiple levels of standard of review. There's the one called de novo, and that means sort of a new, or, it's kind of a new review, but it means the appellate court stands on equal footing with the trial court and gets to look at what the trial court did without any deference to the trial court. And then there's substantial competent evidence, meaning, did the trial court have sufficient, was there enough evidence there to support its factual findings and what it did, and the determinations that it made. And then there's abuse of discretion, which means the trial court would have had to have acted in a way that was completely unreasonable given all the circumstances before it. And there's the seminal Florida family law case, Kanakaris v. Kanakaris, and it talks about the abuse of discretion standard of review and what that means, and what the sort of the reasonable position that the judge would be in, in making its decision. There are some other doctrines out there that intersect with the standard of review, one called the tipsy coachman doctrine. I always thought that was funny, because it's almost like this envision of a coachman on a horse-drawn carriage, and he's tipsy from, drinking a little too much, and that sort of thing. And can he steer it? So that one was always funny to me, but they're not calling the trial judge drunk in that situation. What they're saying is, did the trial judge get to the right result, even if it was for the wrong reason? So, and we get there taking a different path, but you're ultimately going to end up at that result anyway. There's the harmless error doctrine, is like, yeah, the trial judge was wrong, but even in being wrong, it was harmless. It didn't affect the outcome of the situation. But going back to the first three that I talked about, the appellant always wants de novo review. Okay. They want their appeal to go to the District Court of Appeal, or, it won't. In our cases, it won't go to the Florida Supreme Court. It'll go to the District Court of Appeal. They want it to go there under the de novo standard. They want the appellate court to look at it and say, we're not considering what you thought, Judge. We're going to rule on this, brand new, just looking at the record, the paper, the documents in front of us. Generally, that standard of review is the interpretation or construction of a statute, a rule, a contract provision, some like issues of law, for example, on summary judgment. Those are reviewed de novo. And was there a genuine issue of material fact there preventing summary judgment or not? It's those sorts of things to where they're legal. It's matters of law. Okay. Is it a pure question of law? Is a matter of law that the appellate court can look at and say, I can rule on this. I don't need to consider what the trial court did. That's always the best for the appellant. Abuse of discretion is at the other end of that spectrum, and that's what the appellee always wants, is the abuse of discretion standard. Like, you've got to show that the trial court, acted as no reasonable judge in those circumstances would have acted when making its determination. And so the appellee wants that. The appellant wants, de novo. Sometimes there are mixed standards of review depending on what the issues are that you're bringing. And generally it's like, well, are there mixed questions of law and mixed questions of fact that have to be considered? But those are probably for another podcast. So.
Yeah, we could go on, and we will go on. We'll definitely do another one. So, one of the cases we were talking this weekend, and you had mentioned Applegate versus Barnett Bank.
Yeah.
In a prior conversation. Can you tell us a little bit about that and how that plays into the process?
Sure thing. So Applegate v. Barnett Bank is a Florida Supreme Court case from 1979, and it directs us kind of what I had said before, that the appellant bears the burden of coming to the appellate court and saying, the judge got it wrong. And I say that as a general rule, that's the case. And what that means is the appellant has to bring as much as they can to the appellate court to say, here's everything that happened, appellate court, and the record below, because that's what the appellate court is confined to that. I get appeals sometimes, and someone's like, well, we need to tell the appellate court about this, and it's something that happened after the order being appealed. And I'm like, I can't do that. We're confined to the record, to the things that we can properly bring to the appellate court, for them to look at. We can't bring things that are new to them. You have to bring things new to the trial court, and hopefully there's a path there for the trial court to address it, but the appellate court is confined to the record. And what Applegate instructs us is if we don't do everything we can to bring a complete record to the trial court, then our appeal starts to become compromised. And that ties into one of the most common pitfalls. If you don't mind me getting into this, one of the most common pitfalls that I see, and we see it all the time, and our heart just sinks when the appellant is the one coming to us. And that is that there's no transcript of the proceedings. And there are cases that cite back to Applegate all the time and say you didn't have a transcript of the proceedings, so you did not preserve this issue. You did not properly preserve this issue for appellate review. And I always tell people in advance, if it's worth going to the hearing, it's worth hiring a court reporter so that you could have a transcript in case something goes awry. Because Gerard, I've gone, and I'm sure you have too, I've gone to case management conferences where the trial judge is just like, well, I'm just going to order this now. I think you told me a story, a judge is
I told you one this
yeah,
weekend. I went to a
I'm just going to, I'm telling you to draft an order to divide the house. You're going to give the house to the other party. I've gone to case management conferences where judges changed the time sharing before, and this is, you can't do that, but they do it. And if you don't have a court reporter there, it's very, very hard. I won't say it's impossible, but it is very, 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 very hard to win on appeal if you don't have a transcript of those proceedings.
I had a case recently and we were kind of late to the game and there was an issue. The case has already started, was underway, and we had a hearing set and we were in the Zoom room, everything, ready to go or well in advance of the time. And for a reason, there was a technical issue and we were never let into the Zoom room. We had, a court reporter there and our paralegal, and we're able to get some affidavits together, and we filed a motion for rehearing based on excusable neglect of the issue with the Zoom. It was beyond our control. And it did not look like it was going to get legs. We did get our hearing set, but I noticed that the court reporter there, I think, had bearing on how that went and how we got a second bite at the apple. And that, because I honestly think that it reminds me of an older gentleman I worked for when I was a teenager. He was a World War II vet. He said a lock doesn't keep a thief out, but it keeps an honest man honest. I think the court reporter keeps the proceeding very honest because they're very aware that there's going to be a transcript of this and how it's, how it was conducted, what was said. I also think that, in my opinion, in the trial court level, it can often be, if it's a small, insignificant thing like a CMC or pretrial conference, having the court reporter there, I think, signals the magnitude of how serious you're taking the case. I also think that it puts them on notice that you are willing to appeal and that you may not have that desire, but you have the tools to appeal if need be. And I think you can sometimes really avert a disastrous turn in the case by simply having the court reporter there. And as somebody who does a lot of the trial level work in these cases, the number of times I have to argue about we need to hire the court reporter and you need to pay for the court reporter, I think that's something that really, if you take nothing else out of this whole podcast, the court reporter is an essential part of the process. And as soon as you don't have one, it'll be the day you need it.
Yeah. And a lot of people, in our family law proceedings, many times the case may be referred to a magistrate, and magistrate proceedings are recorded electronically within the courtroom. And so that allows you to get the recording and hopefully take it to the court reporter to be transcribed at a later date. However, I've had experiences, and DV cases are like this too. I've had experiences, though, where there's something wrong with the recording and the court reporter can't hear, certain crucial parts of the hearing. There's just, there's something askew or amiss with a recording, and you don't get a clean record. And so I even take my court reporters to those proceedings as well, recorded or not. And I've seen people who a lot of times in the self-represented pro se realm, they've been in front of magistrates before. And so it's like they're recorded, and then they end up in front of a circuit court judge, and those are not recorded, and they don't know that. And they call up the clerk and they're like, oh, I need the recording. And they're like, it wasn't recorded. So, there are a lot of little pitfalls there with making a record, and the court reporter, having a court reporter there is, in my opinion, the biggest one.
I think that you're spot on with, I think people expect, with technology being where it's at, that these proceedings would all be recorded. Sometimes I've wondered why they don't have a backup.
Yeah.
I think the reason they don't have a backup may be telling on why you want the court reporter there. Because, I think you were asking me the other day, we were talking about recording devices, and I've asked the judge before if I could use my phone to just record the pronouncement so I can type the order up, and I have been nicely shut down on that they do not want that. They cannot bar the court reporter from being there, though. And I
Right.
do think that's, yeah, something that's essential, and it's, something that's not, instantly, ascertainable unless you've ordered the court reporter. So don't rely on that. There's going to be a recording of it.
Right.
Talk with your lawyer well in advance, and, go ahead and pay the sitting fee and get the court reporter lined up. And, it's essential because, like Jerry's saying, if you don't have a transcript, you're pretty much out of luck unless it's on the. And I don't want to steal your thunder. I think it has to be on the face of the order then that
Right.
where you're out of luck.
Yeah, you have to have fundamental error many times, that has to appear on the face of the order. And one of the most extreme examples, that I could think of is in a chapter 61 in a family law proceeding, a parent having their parental rights essentially terminated as if it was under chapter 39. And it wasn't even that proceeding. But, you can see things like relief being granted that's not in the pleadings, or the court not making, again, the findings that need to be made. There are other procedural issues we would need to discuss with that. But, for example, a court just says, I'm going to order you to pay the other side $10,000 in attorney's fees. And there's, no findings as to the reasonableness of the rate or the number of hours expended, or, anything of that nature. There could be some traction there, but then, there's always a counter argument. Well, you don't know if they tried it by consent, at the proceeding, because there's no record. They could have said, we agree that's reasonable, or they could have tried those issues or failed to object or whatever else. And that goes into further issues of preserving that record for appeal, making timely objections, that sort of thing. But most fundamental portion of that is, if there's no court reporter there to take down what happened, what was said, and what was talked about, it really it hamstrings the appellant in getting that done.
You know, we're going to probably run over a little bit, but I think it's well worth it. One of the, issues I've seen pop up at the trial court level is I'm trying to create a record. I have the court reporter there. I make my objection and I hear, oh, I'll take it under advisement.
Mhm.
And I don't really get a ruling. I don't get it, and to me, that puts the trial attorney in a bad spot.
Mhm.
So I certainly don't want to be disrespectful to the judge,
Right.
but it's my understanding I really need to get a ruling on the record.
Right.
If not, I don't know how that turned out. And if, and there's nothing maybe there to appeal because I don't have it. Is that right? And,
Yeah.
if so, how far can what advice can you give about how far to push the judge into getting a ruling, or what can you do if the judge doesn't rule?
So, one of the things that I always try to, get the judge to realize is, like, Judge, I've heard you and I appreciate that. I really need to, make this clear on the record, or I need to be able to, make a proffer or something of that nature, depending on what the objection is and what it's dealing, or, what the evidentiary ruling is, or the objection is, and what the judge is ruling. And, I think you get a lot of traction from at least most reasonable judges, who will say, it, but I think you're right. Having that court reporter there is crucial when you say these things, to say, Your Honor, again, I've heard you. I respect what you've said. I don't want you to think that I don't, but, I need, to have something clear on the record, or I need to be able to state this position, or something along those lines. And because a lot of the points of law that come out of Florida cases talk about, preserving things on the record. So going back to your example, the judge says, I'll take that under advisement. You can handle it, I think, in one of two ways. First, you can do what you've said, which is, Your Honor, I respect that. I appreciate that, but I really need a clear, unequivocal ruling on the record, on this issue, because you don't want to be caught in a position where you waive that. Okay. Or I think you could say to the judge, thank you, Judge, just at some point in time before we conclude the proceedings, I need a clear ruling on this, and we may need to, reserve our right to present this evidence, call this witness, whatever it is, that it's dealing with, we need to reserve our right to address this issue down the road. And before the proceeding concludes, having the memory and the wherewithal to say, Judge, we need to go back and revisit this so that we can get a clear ruling, so that we know how to address this point.
Well, it wouldn't be, a full podcast, and we wouldn't be giving the audience everything we could if it wasn't, we didn't get to some hot topics. I think we went through all the procedural stuff, but, one of my favorite things to do with you is kind of talk about the hot topics, especially we find ourselves in the First District Court of Appeals, which is not necessarily aligned with a lot of the other district courts of appeal. I just wanted to pick your brain, and seems to be kind of a recurring issue, at least in our neck of the woods, about retroactive alimony.
Yeah. So there are a couple of cases that have come out recently out of the First District Court of Appeal, as you've mentioned. One of those is Iorussi v. Iorussi, and it's a case where the wife, now former wife, was looking for retroactive alimony, and it's my understanding that neither of the parties took issue with retroactive alimony being awarded. They were just kind of taking issue with, the amounts, the nature of it, that sort of thing, whether income from assets, there should have been income from assets or investments, counted against, or counted in the former wife's favor for purposes of income and calculating alimony. In the appellate court, particularly in a concurring opinion, I believe by Judge Long, essentially said there's no such thing under the statute, under Chapter 61, for retroactive alimony. And we're seeing this sort of trend a lot that says in these family law cases, you have to go to the court and you have to ask for this relief prospectively, whether it's temporary alimony, you've got to file a motion, and that's really governed by Section 61071, not 61.08, although, and that was more of a Williams v. Williams case, although then the legislature amended 6108 and added temporary alimony as a form of alimony. But you've got to go and ask for these things ahead of time. You can't wait to get to the final judgment and then say go retroactively from the time that the case is filed to get, retroactive alimony, although, retroactive support has been something that's been contemplated. It's been, awarded. It's been upheld on appeals. And you get to a contemporary case, I'm probably going to mispronounce it, Gerard, Gimbolo v. Gimbolo, and that's spelled Guimbellot, but a contemporary case that essentially said, hey, we had this other case. And I'll mention, by the way, and this is very interesting, in the Iorussi v. Iorussi case, the majority, there's a footnote in there that the majority says Judge Long wrote about retroactive alimony as concurring opinion, and we agree with him. So the majority essentially adopted the concurring opinion in that case. And then Gimbolo v. Gimbolo said, hey, we just ruled there's no retroactive alimony. It is a fiction of essentially case law. It's a creation. It's a judicial creation. It doesn't exist in statute. It can't be done. Okay. And Judge Makar, who is now over on the Fifth District Court of Appeal, but he was on the First District Court of Appeal before, because the District Courts of Appeal realigned in Florida. We added a sixth district recently, and some of the maps of the circuits that the District Courts of Appeal were responsible for were redrawn. But Judge Makar is on the First District Court of Appeal at the time. He's like, for 40 years, retroactive alimony has existed in Florida. And if the legislature did not think that that was correct, they could have addressed that in the law over those 40 years, and you're essentially disrupting 40 years of, legal precedent, whether or not you agree that case law is precedential or not. Some of our appellate judges don't agree that it is, unless it's an en banc decision or it's decided by the Florida Supreme Court. But if it's just decided by 3 judges, and that's how most appellate cases are decided at the District Court of Appeal level, is 3-judge panels. But your Judge Makar said you're disrupting all that precedent, and, you're essentially, throwing things into disarray that don't need to be thrown into disarray. And I think the other point that goes along with that, and again, there's some philosophical differences, but, Chapter 61, it starts out saying that the statute is to be construed liberally. And, early on, it says that courts hearing Chapter 61 cases, family law cases, most family law cases in Florida, are acting in equity. And much of the case law over the years, that have dealt with these proceedings have said that, trial courts are to exercise broad discretion to do equity in these proceedings and everything. And so there's some tension as to whether or not the appellate courts are honoring Chapter 61 and the legislative mandate to construe all of the provisions in Chapter 61 liberally, because that's what the legislature has done. And it doesn't say that in most Florida statutes. It says it in some, but there's direction there from the legislature when it wants the appellate courts and the trial courts to operate and construe the provisions liberally, and Chapter 61 is one of those areas.
We're talking about that the other night, and I have to agree with you that historically there are courts of law, which are, like you were explaining, the de novo review, very strict, just legal principles. And then when you get into some of these equitable principles, you have to have a little leeway to be fair. And none of these cases are, they're all unique. They have different facts and different circumstances. And I think that, you can read a statute so strictly that you can just basically read the intent right out of it.
Mhm.
And I think that, that's something to be cautious about with where things are going, or the legislature is going to have to get very active and really dot every I, cross every T, come up with every possible scenario, which I think with family law is almost impossible to cover every possible scenario, because I've been doing it now for 21 years, and the cases, no case is the same. It's just
Absolutely.
they're not vanilla and chocolate and strawberry. They are very unique snowflakes, and they have their own distinct characteristics and procedural history. Let me ask you this about Iorussi, and I might not be saying that one correctly. So in cases where you file your temporary relief motion day one, right out the gate for temporary alimony, and you have to wait, for an answer, see if the other side's going to answer. Got to do the mandatory disclosure. So, hey, there's another 45 days. Got to set the hearing. Other side may be difficult in setting the hearing because they don't want to pay. Attorney may get it continued, and this goes on. When we're talking about retro, do you think it can go back to the date of the petition, or the date of the motion for temporary relief,
I don't know.
or do you think you're stuck? That's one of my.
Yeah.
If I could ask the First District Court of Appeals a question, just what happens there, because I have seen, scenarios where that temporary hearing goes on months and months and months before you actually can get it heard, and then it seems like there's no recourse for the person, even when they asked prospectively day one. That's been something that's been burning in the back of my mind. I haven't seen an answer to it yet, but I knew if anybody had probably read the case or saw something like that, it'd be you.
Well, yeah, I'm not going to presume to know that answer definitively. I certainly think that that's an argument, and we try and we do the best we can as attorneys. One of the things that I think is a struggle for us is, we're attorneys for our clients. We're supposed to be quote unquote zealous advocates for our clients and their positions, but we're also officers of the court, and, we're expected to behave in certain ways with certain levels of decorum. In a lot of these cases, I tell my clients, and going back to what you said, every divorce is different. And I tell people, when you've seen one divorce, you've seen one divorce. It's yes, every divorce is different. And they're very factually dependent. But the other things that I tell my clients is a lot of these cases are about appearances, and you want to appear. And hopefully you are, in fact, because you want to appear to be authentic, but you want to appear to be reasonable, when the court's dealing with you, because the court's going to be more inclined, to go your way if you're not taking unreasonable positions. I would think, I would hope that, there's a statutory section 57105 that deals with unreasonable delay. That might need to be employed some, unfortunately, if people are just trying to delay proceedings intentionally to avoid paying alimony, to avoid paying attorney's fees. But I would hope that neither our trial courts nor our appellate courts would award that people are just trying to stonewall proceedings, and stonewall their progress forward. I would say that we could even take a position of filing a motion with the court to abate the proceedings until the court hears a temporary relief order because of the precedent, because of the points of law being released from our appellate courts, issued, distributed, whatever, from our appellate courts, because we could run the risk. There's not just Iorussi v. Iorussi, but another one we've talked about a lot, Haslauer v. Haslauer.
That's where I was headed next.
Yeah, that came out in March of 2024, and that deals with attorney's fees. The history has been in these cases to where we might take on the spouse who doesn't have the money, but there are assets there. The other spouse does have the money, and we're like, look, we're going to float this, through to a final hearing or some other substantial hearing, because we know there's money there to pay this. We know under the law, the financial resources of the parties is such that, one party should, the party I represent has a need for attorney's fees, and the other party has the ability to pay it. And under Section 61.16 Florida statutes, as it's been construed by Rosen v. Rosen, says that you're to consider the financial resources of the parties and other circumstances in the case, including, in determining those financial resources of the parties, what the equitable distribution award is going to be, or what the alimony award is going to be. And of course, how do you know those things until you get to the final hearing? And so we get to the final hearing, and then, you determine there should be an attorney's fee award too. But then, a case like Haslauer comes out, and it relies, I believe, on some dicta from Jessup v. Jessup, which is a 2022 case, that says, no, that provision is only supposed to go into the future. So the statute says the trial court may, from time to time, award a reasonable fee, cost, suit monies, under a Chapter 61 proceeding. And then you get cases that start saying, well, from time to time only means going forward, not back.
Right.
Well, who's to say that? Okay. The legislature didn't say that. The legislature just said from time to time. So why can't from time to time be looking back during the course of the case?
I'm going to tell you, like, from our end of things at the trial court level. Now, when we have these issues and we come up, we're trying to do a motion for attorney's fees early on. We're putting together a litigation budget, a spreadsheet basically of what we anticipate hours to be, costs, and we're having to speculate, to be honest with you, and having to take a moonshot to guess as to what's this going to take to either get to another fee hearing or to the final. And then we have a lot of, what it feels to me, a lot of pushback on, well, how do you know you need that? Or how do you know what's going to happen? Or how do you know it's not going to settle tomorrow?
Right.
And then what you said, we've always operated under, I call it the order of operations of divorce: peace, parenting, equitable distribution, alimony, child support, and everything else being the attorney's fees. Because if you don't know what the alimony is, you can't figure out the child support. You can't figure out, what the assets and resources are without the equal distribution, and all those things being solved for first, to be able to figure out if there's really a need, or a need and ability to pay for attorney's fees. If you have the judge grant it early, it could be that the person at the end maybe wouldn't have the resources to do it. It could prejudice the person who may be the moneyed party, who would be more likely to have to pay the fees, and to the party who needs the fees. At that point, I tell people we have to get our crystal ball out, and we have to start guessing
Right.
as to what's going to happen and what's this going to cost. And to me, I read it like you, from time to time. It seemed that the legislator was sufficiently vague and broad to give discretion, and I think it's now have been narrowly construed, which causes a lot of problems. But
Yeah. And I mean, it really drives up the cost of litigation, because you're having to file these motions for interim and temporary relief when otherwise you may not have to. On both sides, generally, if you're experienced, marital and family law attorneys, and you're reasonable people, and you're going to know, like, hey, look, if this is how it's going to shake out when we get to the end of it, I know that there's going to be alimony. I know there's going to be some attorney's fee obligation. I actually settled an interim fee motion with another attorney, very reasonable attorney over in the Jacksonville area. I commend her for it, but we had a motion for interim fees, and we negotiated language in there that they agree that a final fee award could be determined at the final hearing. They would not apply the principles of Haslauer v. Haslauer or any cases, that align with that, and that the court would reserve to make that determination once we knew how the equitable distribution is going to shake out, the alimony is going to shake out, and that sort of thing. And I think that that's a very reasonable approach too, because I think, again, if you have reasonable family law attorneys, they're going to know, like, look, if we have to go to these interim hearings over and over again, it's going to drive up the costs. Even if you represent the party with the money, it's going to drive up the costs for them too. Okay. And if the court denies it, okay, well, then you've got a 9.130 appeal, because that's the right to immediate monetary relief. That's one of those. So then we've got to file interim appeals. Okay. Or if they awarded too much, I've been on this side too. If we thought that they awarded too much, we have to file an appeal to deal with that, because the judge is like, all right, well, I'm going to shoot high, because I've got these decisions saying this is only prospectively. So now I have to shoot high. I'm going to award, a huge amount in order you to pay it. Okay. And there's no findings the person has the ability to pay it. Again, there's no competent, substantial evidence to support that that's the amount that's going to be needed to get through the case. And like you said, how does the person with the money, how do they get it back at the end of the case from the person that doesn't have it? Now, the court possibly could say, I'm going to order this, and to the attorney that it's going to be paid, I'm going to order that you hold it as an advance fee under the rules regulating the Florida bar. Again, a whole nother topic, but a lot of times we refer to taking money and holding it in trust as a retainer. It's really not. It's called an advance fee, and you hold it in trust and you bill against it. And then, whatever you don't bill against remains in trust, and that's the client's money. I suppose the trial judge could order the attorney, you're going to hold that as an advance fee. Okay. If you don't use it all, it's going to be refundable to the party who paid it, as a form of protection. I don't know, all of the answers, but, you could conceptualize different things. But if there's no protection and you get to the end of the case and all those fees are gone and they shouldn't have paid them in the first place, because of how the equitable distribution award shook out, how, you equally divide all the assets, you equalize the income through alimony and child support. And this is what Haslauer talks about. And I think Haslauer didn't need to go as far as it did, because you had an equal distribution, you equalized the income. Okay. And then most often, once you have those circumstances, the appellate courts say attorney's fees aren't appropriate anyway, because the parties are in an equal position to pay attorney's fees when they get to the end of the case. Right. And that's really where Haslauer started. Okay. And then it went further in its opinion as to whether or not, you can even have fees going back, or the other aspect of it in that case was one of the parties financed their attorney's fees on credit cards. Okay.
High interest credit cards.
Okay. And so there's a debate there as to whether or not, if somebody has to debt finance something, do they have an ability to pay it? Okay. Well, if I need to go finance my car, I don't have the ability to pay cash for my car at that point in time. Do I have an ability that's equal to the other side? Do I have an ability to litigate this case on equal footing to get to the end? So I don't know, again, all the answers. I just know that there are some uncertainties, that may or may not have existed before.
Well, while we're on attorney's fees, and we'll wrap up after this.
Yeah.
Obviously, it's my understanding that you can get attorney's fees for appeals or your appellate attorney under 6116. Am I correct on that?
Yeah, that's right. It's in the trial court and in on appeal for maintaining and defending an action under Chapter 61, and it includes at the trial court and in the appellate court.
So, with knowing what we know about Haslauer, do you have to motion for your fees at the beginning of the appeal, or if you're already paid, or how does that work, or is there any thought on that?
Yeah, because that rule that we talked about early on, 9.600C, says that the trial court can award fees, dealing with appeals as well and family matters. And so I think it's smarter, right, to motion I think if you're the person who needs fees and you have a legitimate basis to ask for fees at this point in time with the state of things, you need to ask for early and often, and you really need to push your trial judge to award it. And if the trial judge denies it, then that's another thing to where you can ask the appellate court to review that motion while the appeal is pending and send it back to the trial court for reconsideration.
I know this last one is a real hot topic. What about in paternity cases?
Right, right. So chapter 7 or section 742.045 mirrors section 6116 in a lot of ways. And in the language, it mirrors that language, but it differs in one important way. And it doesn't include appeals under 742.045. Chapter 742 governs paternity proceedings. Now, there's been a lot of debate as to, okay, well, I've got a paternity proceeding, but that chapter incorporates chapter 61 in dealing with child support and creating parenting plans, time sharing schedules, and that sort of thing. So there's the idea that you could file a motion for fees. Well, you could plead for fees, okay, when you first file your paternity case under both chapters, right? And then if there's an appeal involved, there could be an argument like, well, yeah, I'm not really appealing the paternity determination. I'm appealing the child support or the parenting determinations, and those are under chapter 61. So, that's where the appeal. So I should get fees in appeals there. So why you raised this topic, and I know this because we talked about it before, but I also know this because of the committee work that you do in the family law section and the things that we're dealing with. And there's a decision out of the 6th District Court of Appeal, and there's one out of the 3rd District Court of Appeal now that are dealing with appellate fees. And the 6th District Court of Appeal is its initials, it's CT, and sorry, my mouse is misbehaving, but I was going to talk about them here for a second. But it's CTVTG, and that's a 2024 case. And then there's Perez Palma v. Rodriguez out of the 3rd District Court of Appeal. That's a 2025 case. And it says that because 742.045 do not include the word appeal, does not include the word appeals, they can't award appellate fees. So, yeah. So that's a really hot topic now in paternity cases for the longest time. And there's a couple of other cases that these courts have certified conflict with, meaning, they can go up to the Florida Supreme Court for the Florida Supreme Court to make the determination. And I understand that that is in the process, that the Florida Supreme Court has initiated the review of those cases. And if it takes jurisdiction, then it'll, make a decision on the merits as to whether or not 742.045 includes, appellate fees. But I'll say this, that the Florida family law section of the Florida bar is involved in coming up with other alternatives, to work with the legislature to consider, whether 742.045 should be amended to include appeals, because in all other respects, the language mirrors 61.16. So, they're pursuing other ways of addressing this issue and coming up with solutions. And I know you're involved in that, Gerard, and I commend you for it.
I appreciate it. Well, Jerry, we set out our goal today was 45 minutes and we're at an hour and a half. I told you it would fly by. Anytime we get to talking about this, it goes, it goes and goes on its own. It's always great to talk with you and pick your brain about, all these academic issues, appellate issues. And, we had dinner this weekend, and your wife is a family law attorney at your practice as well, Olivia. And I hope she enjoyed it as much as we did, because I started thinking after I left, we may have bored her a little bit, but she's absolutely wonderful too.
Yeah. No, didn't bore her at all. She loves these conversations. She enjoys your company too. And she and I have these conversations often as well. And she's Olivia Brooks. She's an instrumental part of our appellate practice. She handles her own appellate cases. We work on them together. We're very much a team and collaborative with each other in this office.
Jerry, before we sign off, if I'm a family law attorney and I'm having one of those moments where I think I better get the appellate lawyer now.
Hmm.
I better get some advice, some guidance here to try to avoid having to do an appeal. Or, hey, the ruling has come in and I'm now shopping for an appellate lawyer. How do people get in touch with you?
So they can call my office at 850-201-0942, or they can email me at JLR, that's for Jerry Lewis Rumph, JLR at brookslawyers.net, BROOKSLAWYERS.net.
Well, Jerry, thank you so much for giving us your time, giving us your knowledge, and going over this, kind of elusive area of the law. I think that confuses a lot of people, and I'm not going to forget your Wizard of Oz analogy because I think that was spot on. Because it is a big curtain of uncertainty. What's going to happen next on the appeal. I know, like I said, we were at dinner parsing out the finer points of child custody issues and the factors the other night, and we'll have you back on to talk about a variety of topics. And the whole purpose of the podcast is to give people good information from people who either are litigating family law cases, appealing family law cases, or ancillary, whether they're forensic accountants, psychologists, other people who kind of work in this field who can offer really good quality information. So if everybody out there could subscribe, share, if you know somebody's going through something like this, direct them to the podcast or get them the information. That would be great because that's the whole point. There's a lot of great information generally out on Google, but it's better to just interview the people who do this for a living and get the better information out there. Hopefully, make the connections to the people you might need to talk to. So, Jerry, thank you, and we will have you back on soon. And thank you so much for everything.
Thank you, Gerard. It's great to be here.
Thank you.
All right.